Ask Reddit. Lawyers of Reddit. What is a detail that your client failed to bring up to you that completely lost you the case? Part 2. My father is a judge. I remember him talking about a case where a woman was suing for a severe back injury that she said was preventing her from working and taking care of her kids and so on. In the middle of the trial, a pen rolled off the table and she is bending over trying to reach it from her chair, but pen was too far away. So she stands up and bends over and picks it up and goes back to her seat as if nothing is out of the ordinary. My dad is just looking at her and she snaps at my dad and goes, "What are you staring at?" My dad asked her if she was okay and her response was that she was fine. Her attorney leaned over and said something to her, and then she loudly started complaining about her back and how much her back hurt, but no one believed her. LOL. This one ended my marriage. Well, it was the start of the end of a marriage. My husband lost his job in the title mortgage business. Applied for unemployment, got denied. I decided to help him with his appeal hearing. I asked him multiple times before the hearing, "Is there anything you did that caused them to fire you?" He says, "No, absolutely not. They fired him out of nowhere." Hearing day comes. He testifies under oath that he did nothing wrong, was a good employee, no issue. Upon cross-examination, the other attorney pulls out documents from one of his real estate closings. Documents he forged and backdated. Had to admit he perjured himself. Needless to say, he didn't get unemployment, and he didn't sleep at home that night. I and all. And it's not even my stories, but my dad's. He was working as a fraud investigator for an insurance company. I have a few stories of his, but here's 2 of them. Guy was claiming theft of multiple items, but mainly a ring. Things weren't adding up, so my dad and the insurance company's lawyer decided to go do a depot of him. Guy shows up and is doing the depot when my dad notices the guy is wearing the exact same ring he's claiming was stolen. My dad slides a note to the lawyer telling him the guy's wearing the ring. Once the note got slid, the guy realized what happened and put his hands under the table and took the ring off. They asked him to stand up, and lo and behold, the ring fell to the ground. Another one is a guy claiming a break-in and theft. Immediately, things weren't adding up as the window was broken out instead of in. The guy submitted Polaroids of items he claimed were his, like TVs and such. Thing is, the Polaroids, you could see the reflection of the store they were in on the glass. He also claimed numerous CDs, records, but oddly enough, every single one of them started with an R, S, or a T. We're talking hundreds of CDs records. My dad was about to deny the claim in person, but noticed he had a gun on the table, so he decided to do it over the phone. Ready for an escalation? Later, the same guy was arrested for beheading a prostitute and throwing her head in the river. Not my case, which is a gift from above, really. Civil trial before a jury for injuries and prop damage from an MVA and punitive damages because defendant was intoxicated at the time of the accident. Let's call defendant DUI. Almost doesn't need to be said, but before DUI ever stepped foot in court, they would have been prepped repeatedly, first for the depositions and then for the trial testimony, with the standard questions. Were there any prior incidents, arrest convictions, anything that can be used to impeach any of DUI's testimony, yada yada, over hours. Denies everything and is as clean as a clean whistle. Thus, at trial, defense counsel puts DUI on the stand to give them an opportunity to tell the jury of their contrition for this one-time error in judgment, describe the difficult time DUI was going through at the time, and otherwise show themselves to the jury as an upstanding member of society in order to reduce punitive damage. It goes well. Then plaintiff's counsel gets to cross. I'm going to paraphrase what allegedly happened next, which is purely hearsay. PA. Earlier, you testified that this was a one-time mistake and you've learned from your lesson. Is that correct? DUI. Yes. PA. Isn't it true that you've already been convicted of a DUI in another state? DUI sits silent as DC immediately objects, but it's properly overruled and DUI must answer. Since what happens next is impeachment, I'll skip the objections, but suffice to say they were being fired off as rapidly as a machine gun and just as rapidly overruled. DUI. Yes. PA. And isn't it true that in your prior DUI, a child died? You can imagine what's happening in the courtroom and, most importantly, amongst the jury. And you think it's over. Stick a fork in DUI, it's done. But then, PA goes for the jugular. Do you remember the name of that little girl that you killed while you were driving while intoxicated? IMO, this question is one for the ages, more powerful than the old. When did you stop beating your wife? Because no matter how you answer, and that is why you never ever lie to your attorney. Not me, but my mentor. This is the reason you never ask questions that you don't already know the answer to in court. During the trial with the judge on a divorce matter, the wife brought up that he had abused her during the course of their marriage. Client whispers to my mentor that this is absolutely not true. On the stand, during his portion of testimony, my mentor asks, "At any point in the marriage, did you lay your hands on your wife?" One time we were having an argument and I held her down on the couch until she stopped arguing with me. What? My mentor said it was like she could see it happening in slow motion and all of the alarm bells were going off in her head because she had never mentioned this, and apparently to him, this was not abuse. The judge gave wife a lot more money as a result, and husband was baffled. My mentor was fuming. Husband admitted this was the only time he laid hands on wife. My mentor was more peeved because she had thought the case was in the bag since wife had abandoned the kids with the husband to run off with her lover down in Florida and literally only came back to the state to get the divorce done. Husband had been noted as being a great dad to the kids and a good figure in the community, hence why she was so damn shocked at his answer. I was approached by this attorney to work for him for free to go after smugglers. This guy had been arrested for dumping goods onto American markets that violated trade agreements. In his arrest, a bunch of goods were left in the warehouses to rot, and their owners, his clients, were never paid. This attorney showed me that this smuggler had assets, and that he had gone to the criminal trial and gotten the judge to set aside $2 million of the criminal penalties to settle his client's debts. He had receipts, invoices, all of the paperwork. He just needed associates to help him take the case to trial. He wanted me to work for free, but he would pay me on the contingency once he obtained the verdict. He had 2 other attorneys working for him with the same deal. I worked on the case for a short while, but luckily moved on to other things. The other 2 attorneys worked on that case for over 2 years. At one point, they negotiated a $1.5 million settlement of all claims. The attorney in charge rejected the offer because he was convinced he could get twice as much at trial. In the end, the case settled for $200K because none of the clients would enter the United States to testify for fear of being arrested. The 2 associates got $8,000 apiece for 2 years of work. I'm still a law student, and this happened during my first internship at a court. A girl among other people was charged with drug possession, but because she had thrown away the drugs and the police couldn't prove that she bought or owned the drugs, because it could have been one of the other people as well who still had drugs on them, the judge ruled in dubio pro reo. He then asked if she wants to add something, and this girl asked if she could get her drugs back. The defense attorney looked like he was about to get a heart attack. I had a client who, despite being a large man, had been domestically abused by his much smaller wife throughout their marriage. After the divorce, she turned her anger on their son. He ran away one day to live with his dad, and we filed to restrict her parenting time and for a permanent modification. At the permanent hearing, she denied being abusive to the child or my client in front of the child, said she never threatened anyone ever, and that she never made disparaging remarks about my client in front of their son. What she didn't know, and therefore hadn't told her attorney, is that he had recorded multiple instances of her abuse. So I called my client back up for rebuttal and played an audio recording of her screaming at my client, threatening to break his face and calling him a loser, all while the child could be heard in the background begging her to stop. I looked over at the other attorney and she had her face in her hands. We won. Years ago, I had a client charged with drunk in public. It's a minor infraction, but he was on probation, so he needed to fight it. He told me he was very drunk that night, but had made it to the lobby of his brother's apartment and was waiting for him to come down to get him upstairs. I take this information and run with it, bringing photos of the apartment complex and the bylaws to court. My goal was to prove that the lobby of the apartment was secured to guests and residents only, which would arguably take the drunkenness out of being in public. There is no formal discovery for minor infractions in my state. Since there isn't a real option for a plea deal on the minor charge and wanting to ambush the officer with my argument, I do not discuss the case with him and we go to trial. The wheels come off the wagon when the officer testified that he encountered my client at an apartment building on the other side of the city. He was outside at the call box, not even in the lobby of this different building, rambling and barely able to stand. I'm whispering to my client about his reversal, and he slumps over and says something to the effect of, "Sorry, I meant to go to my brother's apartment. Maybe that's why he couldn't find me." And he sounded angry on that phone. Cross-examination was not fruitful. It was basically, "Officer, are you really sure it happened where you said it did and not at this other apartment building miles away?" Closing argument that he wasn't that drunk also didn't get us anywhere. In the end, there was a fast guilty finding, a minor fine, wasted ink, and paper from printing useless exhibits, and light sanctions later on the probation violation. Employment law matter. He claimed to have been unfairly dismissed over bogus performance management. The real reason? He organized via Craigslist to have someone collect a box of his cum from a child's playground. There were explicit messages from him asking what they did with it and whether they rubbed it all over themselves. The employer provided us with the messages. FDA dismissed a guy for insider trading. He would access a database of drugs about to be approved, which nearly always caused stock to go up. He made millions buying stock in his family's name to cover his tracks. But he made a fatal mistake. He looked at the database and then bought stock with his work computer, which FDA owned and could search without consent. You click a statement to the effect each time you sign on. If he'd waited and done it on his own computer, they'd have to get a search warrant, a much tougher proposition.